Hi, everyone. I'm going to go ahead and start talking because I'm being recorded. So my name is Emily Weiskopf, and I work for Legal Aid of Northwest Texas in Denton. Pardon me, I'll try and speak up. I talk quietly sometimes. So we are here this evening to talk to you about estate planning, property preservation, and some other things that are important. Sorry. That's my own feedback. That's a little embarrassing. Thanks for bearing with me as I figure this out. Okay, here we go. So we're going to talk to you this evening about estate planning, property preservation, and wills and estates. So I'm just going to give you a little bit of information about our organization, how we help people, and then I'm going to turn it over to Ms. Jennifer Cannell, and she's going to talk to you guys all about the reason why you're here tonight. So thanks for Denise and Rachel at the Decatur Public Library for putting up with us and helping us do it this evening. We really appreciate it. And anyway, I'm going to get started. So really briefly, Legal Aid of Northwest Texas. We are a nonprofit organization. What we try and do is we try and help provide civil legal services to low-income individuals all over North and West Texas. There is a big gap in civil legal needs for people all over. And so we help people in DFW and the Panhandle and all the way down to Midland and Odessa. So as you can see, we have a 1.5 million eligible clients in our service area, and we have a lot of people that do what we do, which is really great. And there's about 10 of us in our Denton office. So our Denton office provides services to Cook County, Denton County, Jack County, Montague County, and obviously Wise County. So we cover a pretty big chunk of Texas. So free civil legal services. So what we do is we help people with stuff that's not criminal law. So especially during COVID-19 and the pandemic and everything going on after it, this has been really important. And so we've been helping people with a lot of landlord-tenant disputes. We help people with family law issues. We help people keep their public benefits and get access to public benefits. We try and keep people in their homes. And we also try and help people recover from disasters. And we try and help people, obviously, with property preservation and estate planning needs and all sorts of stuff like that. So we don't help people, unfortunately, with medical malpractice claims, class action lawsuits, any of these touchy subjects up here, and we can't provide representation in criminal matters. The one sort of caveat and asterisk that I will say to this is that we can help people with non-disclosures and expunctions of eligible criminal records. So there are some circumstances in which we can maybe help someone clean up a criminal record that they have if they're eligible according to state laws in Texas. So that's one way we can sort of help with stuff like that. We also can help people get their driver's licenses back after surcharges have been removed and stuff like that, because surcharges aren't real anymore. Anyway, I'm getting off topic, but just a couple of things to keep in mind. And actually, we're doing another presentation with the library here in Decatur on the 24th to talk about that of September. So if you're interested, come back and we'll talk about it on September 24th. So anyway, so how we provide services is that individuals have to be eligible for them. So we want to make sure that the people who really need our services are able to access them and get them. So we have to make sure that people who come to us are eligible based upon their income. So they are financially qualified, because we do exist to help low-income individuals and individuals on fixed incomes. We have to make sure that they're asset eligible, and all of this stuff is important, but it's not anything that you need to worry about, because this is what we do. But it's also important that you understand, you have to be a U.S. citizen or have some other legal status. And then obviously you have to have a legal problem that we can help you with. But, all of this stuff will definitely help you understand. So if you have questions, don't worry about contacting us. We promise we won't scare you with anything, and we'll explain it to you. So income eligibility just means that, you're within the federal poverty guidelines. And we actually have examples of this on our website. So you can go and look to them directly and see what numbers we refer to whenever we help people qualify for our services. So if you have any questions about it at all, you can go to our website and look, and you'll be able to see. So another rule we have is that, people can't have an excess of assets. If someone has $100,000 sitting in the bank, they probably don't need any help hiring an attorney because they probably have the funds necessary to do it. We want to help people that maybe don't have access to that kind of resource because legal fees can be very expensive. So, in order to be eligible for services, people have to be a US citizen or have some other kind of legal status. The one exception to this being that we can help victims of domestic violence in regards to that. Yeah, we help people with that all the time. So this is just kind of an example of some of the priorities we have that we help people with. Just think of it as things you could contact us to help you about if you have questions. We kind of like to stay focused on keeping money in people's pockets, keeping families together, keeping people in safe places to live, and making sure people can get access to the health care and the resources and benefits that they need in order to maintain a good standard of living, and a good life. So anyway, if you're ever curious about applying for services, this is just a very quick rundown of how it goes. You can contact us a lot of different ways that I'll show you in the next slide or two. And what we do is we just talk to people and make sure that, they're eligible and that there's not a conflict of interest, because we don't want to waste anyone's time. We want to make sure that we can connect people to the resources that they need when they need it. And we don't want to waste anyone's time. We want to make sure that we help the right people and get everyone connected to what they need. So after that, we set people up with an intake interview with one of our staff attorneys. And then every week, the attorneys in our office go over all the cases we've received, and we just try and decide the best way to allocate resources and how we can best help people that come into our office. So even though we're, obviously very busy, especially because of COVID-19, we always like to make sure that we try and provide some type of assistance. So we always try and represent people when we can, but we always try and give some good legal advice when possible, or help people prepare forms whenever it's applicable and stuff like that. Sometimes just helping people investigate what the problem is. There's a lot of different ways that a legal issue could end. So that's why it's good to contact us if you have any questions about anything. So, of course, because of COVID-19, we are closed to in-person, our offices are closed to in-person activities. We're not doing anything in person right now. That's why you're all here with us tonight. But we're still here to help people, and we still, want to do our part. So we would love it if you would contact us about questions, if you have any. And information for our Denton office, we have clinics that are still available. So if you need an appointment to speak with an attorney, those are a great opportunity. We have tried to make it as easy as possible for people to get in touch with us about legal services. So you can check our website. Our phone number is right there. We have a legal aid line that's staffed in our Dallas office that you can call, and they have extended hours on Mondays, Wednesdays, and Thursdays, and it's staffed with attorneys. They're a great resource. And you can also apply online anytime using a computer. And I'm sure that the library would be happy to direct you to that resource if you need. And I'm sure they'd be happy to help you in any way that they could. And then we have some extra resources that have just kind of come out of the COVID-19 pandemic. It's just kind of covered the entire time. So, some of them are a little bit older, some of them are a little bit newer. And they're just there if you have questions about anything, or you just need some really good general information that might address some questions that you have before giving us a call. Might be a good way for you to determine if you do have a legal reason to maybe call the attorney, or, just do some investigation for yourself so you can be better informed. There's a whole bunch of stuff there. So we do offer remote legal clinics because we can't meet with anyone in person. So we offer them for counties, but obviously anyone is welcome to attend. So what we do is we ask you to call our office and leave a message. We'll follow up with you as soon as we can, get your information, and then try and get you set up with an attorney in our office, or a pro bono attorney volunteer from the community that volunteers with us. And then we try and provide a free 30-minute, legal consultation, let you ask some questions, get some good legal advice. And, we provide that to people who are financially eligible, qualify for our services. And like I said, if you have any questions, of course, you can call us. The library knows how to put you in touch with us too, because they're great at that kind of thing. And so next week, we're not necessarily doing this through the library, but they're helping us a little bit. We're offering an estate planning clinic. So if you come tonight or if you have any questions and you want to attend, just call and leave us a message. We're trying to offer just services to help people plan for their estates or their medical needs or, property preservation, stuff like Jennifer is going to get into in just a few minutes. And so we'd like to just extend this resource to people if they feel like taking advantage of it and contacting us and seeing if they're qualified. And we'll see what we can do. So anyway, thanks for letting me talk on and on. I really appreciate it. I am going to wrap things up and then let Jennifer talk to you and dazzle you with her information about estate planning and property preservation. And I look forward to doing this again in a couple of weeks when I talk about non-disclosures and expunctions on the 24th, same time, same place. And then, like I said, any questions about the clinic, I think the library has this up on their Facebook and they definitely know how to contact us. So thank you so much, and I will wrap it up.
Hi there, my name is Jennifer Connell. I'm an attorney with Legal Aid here in Denton. I'm going to talk to you a little bit about estate planning and probate, the different kind of documents that we offer to assist our clients who are income eligible. One of the first things I wanted to talk to you about were the type that we offer. We offer, most commonly the last will and testament, the advance directive, a HIPAA release form, a medical and durable power of attorney, a designation of guardian, either for self or if you have a special needs adult child or someone that you care for. And then I'm kind of going to shift into alternatives that will help your family not necessarily have to probate your estate through a court, the most common being the transfer on death deed. The last will and testament either has to be wholly typed or wholly in the testator's handwriting. That means you really shouldn't go online and download a worksheet and fill in the blanks. You either need to write it all in your handwriting or type it all and then sign at the end. A last will and testament can include specific bequests. If you want to leave something sentimental, maybe a family photo album to one individual or a wedding ring to another, or you can leave the whole of your estate in various shares if you want to leave everything to your spouse, for instance, or maybe split among your children equally, or you can divvy up the shares the way you want to. It's a very personal document. The last will and testament needs to be signed in the presence of a notary public. You also need to have 2 disinterested witnesses over the age of 14 in the room, and nobody else in the room, specifically not anybody who is in your will that you are leaving anything to. You can always revoke your last will and testament, provided you still have capacity, you're still competent to understand what you're doing. If you want to change anything in your last will and testament, you can't scratch out an item and write something else in. You need to redo the entire document, because when you sign in front of that notary public, they are swearing, as are the witnesses, that that's what you said at that time. If you go in later and scratch it out and try to write something in, that won't be held up. You can also, in a last will and testament, include a testamentary trust, say if you're leaving something to a minor child, or you can do a testamentary special needs trust. Those are a little more complicated, and again, I'm going to speak generally here because all of these documents are very personal as to each individual's wishes. But what a testamentary special needs trust would do would be if you have maybe a special needs child and you want to leave them money, anything that they get asset-wise from you, as long as the special needs trust is done correctly, would not count against them for eligibility for public benefits. The next document that I draft the most often would be the advance directive. This is the living will. The individual decides now whether they want to be on life support or whether they don't. This kind of takes it off of your family's shoulders, and you're saying now, while you have the capacity to do so, but for this machine, if you were going to pass away, do you want to be kept on the machine? This isn't a situation where maybe you have the flu or you're in a medically induced coma or something like that. This is a situation where it is terminal. It is certified in writing by 2 physicians. And as I said, but for the life support, you would not survive. You can add special instructions to this if you want to do so. Again, this can be revoked at any time while you have capacity, and it must be signed in front of a notary public. It's a pretty serious document. I have had clients in the past who have gone either way. They do want to be on life support and kept there indefinitely, or they want to be allowed to pass as gently and naturally as possible. It's just a very personal decision, and especially, it's prudent to go ahead and fill out whichever you decide. If, for instance, you have a large family that maybe, won't agree as to what should be done in this instance for you. The next document is a HIPAA release form. This names trusted individuals that you consent to obtaining your medical records. The HIPAA laws are incredibly strict. The government has made it very, very difficult to access another individual's medical records. So this document just tells the physicians, yes, I am okay with these people getting these records for me, transferring them to maybe another medical facility. And it's a good thing to have in conjunction with a medical power of attorney. The medical power of attorney appoints a trusted individual to assist you in making medical decisions as soon as the document is executed, or you can state that it comes into play upon your incapacity. Again, in this situation, some physicians will work with a medical power of attorney in terms of the medical records, but I want to stress that the HIPAA form is very easy to fill out and complete, and so I suggest doing it just to be safe because those laws are so strict. As to your medical power of attorney, again, it needs to be someone that you trust who knows what your wishes are. You can choose a primary, and I always suggest that my clients choose a couple of alternates in the event that something has happened to the person that you chose as primary, or if they just don't want to do it. This document must be signed in front of a notary public. Again, you can revoke it at any time. If you do revoke it, you need to make the person who is acting for you aware of this, as well as any third parties that they have been working with. The statutory durable power of attorney appoints a trusted individual to assist you in making non-medical decisions in the event you become incapacitated. Again, you can choose primary or alternates. It has to be signed in front of a notary, but you can revoke it at any time. The same notice requirement applies. You need to let the agent know that you revoked it, as well as any third parties that they've worked with. I mean, that could be a bank, maybe the appraisal district, anyone that that they've done business for on your behalf with. These decisions, like I said, can include financial, property transfer. I mean, it's basically anything that you want them to do except for the medical decisions. A new statute has stated that any appointed agents must sign a certification when the power of attorney comes into effect. They do not have to sign this in front of a notary, but they're supposed to sign it and carry it with them when they act on your behalf. And it just states that they understand that what their duties are as your agent. So that would, let the other third parties, such as the bank, know that they're aware of it as well. A designation of guardian. As I said earlier, this can be for yourself, minor children, or if you have any special needs children, or anybody that you take care of. This names a trusted individual you prefer to act as the guardian in the event that you become incapacitated or something happens to you and you're not able to care for the person or persons you've been caring for. This is not binding on a court, but it does weigh heavily into their consideration as to who would be the best guardian. This must be signed in front of a notary public and 2 witnesses as well. And again, you can revoke it or change it at any time. And just like the other documents, you would need to redo the whole thing. Now I want to kind of talk to you about alternatives to probate. All the documents that I talked to you about before are good to kind of have because they lay out your plans and your wishes. And, I always tell people I'm in my 30s and I have all these documents done because you just never know what's going to happen. In the state of Texas, you only have to probate a last will and testament, which means file it with the court and get an order on it. If you leave real property, if you leave a gift to a charity or to the state, or if a church is a beneficiary. Now, there's kind of ways to get around these things because probate can be costly and time consuming. You have to pay the filing fees. You have to wait for a hearing and make sure all the notice is given. And you have to give the notice to the creditors and to interested parties. There's also considerations if someone were on Medicaid, there's something called the Medicaid Estate Recovery Program. In that instance, if an individual passes away owing money to Medicaid, they could conceivably go after anything in the estate, which would include a home. One of the most useful tools that I use for our clients to avoid having to probate an estate and to avoid the Medicaid Estate Recovery Program, which I'll call MERP, the MERP claim is the transfer on death deed. A transfer on death deed is executed and recorded during your lifetime. And what it does is it basically states upon your passing, the individuals that you choose will have the title to the real property immediately upon your death. You can have a primary beneficiary and you can add alternate beneficiaries. You can have any number of both. It's just important to note that if you have 3 primary beneficiaries, they're all going to take equally. So you can't say I want to leave individual 1 50% and the other 2 25%. They just take in equal shares. In the event that all primary beneficiaries have passed away or are no longer there, it shifts to the alternate beneficiaries who also take in the equal shares. But again, all primary beneficiaries would have to have passed away. One good thing about this transfer on death deed, and a lot of people have concerns about this, is that you retain until your passing all of the decision-making authority for that real property. If you want to sell it, you can sell it. If you want to take out a mortgage on it, you can take a mortgage on it. It is yours, and they have no right to it until the moment you pass away. This deed must be recorded in the county deed records during your lifetime. All of our services are free, and we're able to file court cases with a document that generally allows for no filing fees, but the filing fees for recording in the county deed records is not something that we can waive. That just goes to the county. I would say the average cost for our clients to record one of these deeds in the counties we serve is anywhere from $35 to $45. So it's not the hundreds of dollars it would cost to probate a will, but it is something that we can't have waived for you. This document is revocable at any time, but you also must record that revocation in the deed records so that everyone knows after your passing when, a title company comes in, they see, oh, it was going to this person, but that was revoked. The transfer on death deed protects the real property from the MERP claims because, as I stated, the state can go after whatever is left in the estate, including the home. But as the transfer on death deed immediately takes the property out of your estate, the state can't reach it. It is no longer there. Not everything passes through the probate process. Stocks, life insurance, retirement benefits. You should just always make sure that you are working with these companies so that your beneficiaries are updated and reflect who you want to take. You may also set up a payable on death account with most banks, beneficiaries. There's a form you can get with most banks, and it just says, if I pass away and they bring up my death certificate, this is who I want to take from this account. And it cuts out a lot of the red tape so that, your family members can take care of things quickly and at low cost. When someone passes without a last will and testament or any other kind of plan in place, like the transfer on death deed, that's intestacy. And that just basically states, so there's a statutory formula for who would take in every situation from the person who passed away. This can get very convoluted very quickly if there's stepchildren or mini marriages or common law marriages. I mean, it can turn into a mess very quickly and create huge title issues for real property. Very rarely, but I couldn't say it never happens, an estate could pass to the state of Texas. They do everything they can to make sure that it wouldn't, but that's just how serious it is to kind of get, affairs in order if you can. There are ways, however, if you have a family member who has passed away without a will, there are ways to probate their estate. There's a small estate affidavit, which is essentially setting out their marital history and family history, who would take what based on these statutes. It's heavily recommended you use an attorney for this because I said it gets very convoluted. There cannot be a MERP claim against the estate, or you have to qualify for one of their hardships. So all distributees would have to sign, and 2 disinterested witnesses. This can get kind of difficult where the distributees, generally siblings, are not getting along, or maybe there's a step parent involved. So like I said, it's good to do your estate planning to avoid this. There's the judicial determination of heirship, which is where the court says who the heirs are. The problem with this document is that it requires what's called an ad litem, and that's an attorney who verifies everything in the determination of heirship. And this requires fees to be paid to the ad litem. Generally, these fees are not waived by the county, so it's something that the client would have to pay. The general deposit is $500 at least. The last document that we use is the affidavit of heirship. This again lays out the family and marital history of the person who's passed, and it's recorded in the deed record, so you don't have to go through the court. But it generally needs to be recorded for at least 5 years to give good title to the home. And again, if there's a feuding family or just a whole bunch of heirs, the percentage that each person take could conceivably be very small. One of the last things I want to talk to you about is notary services during the pandemic. I've been calling around, especially in our rural counties, to see, what I can do to assist clients who are out there who need to get these documents notarized. I will tell you that most banks have notaries, but will not notarize the last will and testament. They won't do it. If you have a local insurance agent that you work with, they generally have a notary on site all the time and can usually provide the 2 disinterested witnesses, maybe a receptionist and, an assistant somewhere else in the building. Some cities provide notary services, but you need to call first to make sure. I know for certain I have reached out to the city of Decatur, and they do not, unless it's a city document. There are also online notary services, but try to make sure that you're using a reputable one. And if you can, I think that going to your local insurance agent would be a better option, just to be sure. So thank you so much for having me. It was wonderful to talk to you guys about all these documents. I encourage you, if you would like to talk one-on-one and maybe get some more personalized advice, to call the numbers that Emily gave you. If you're financially eligible, I would be happy to give you a call and speak to you over the phone about everything and work with you to decide what would be, the best options for you based on your circumstances. So thank you so much, and I hope you all have a wonderful evening.